Wait, you need to stop talking. Is
I'm
Mr. Griffin, are you Mr. Griffin or not?
I am Anthony of the Griffin family.
Are you the Anthony Griffin
executor of the
that is
estate
charged?
of
Stop a
Anthony
second here.
Griffin.
If you keep talking over me, we're gonna cancel
You've been
this.
talking over me. Matter of fact, Your Honor, are you responsible for me if something happens to me?
This court appearance might just be one of the most bizarre and fascinating displays of sovereign citizen behavior we've seen in quite some time. From the moment the hearing begins, the defendant refuses to follow even the most basic courtroom procedures. He continuously interrupts the judge, talks over everyone, and completely ignores the repeated instructions to stop. What follows is a chaotic stream of conspiracy claims and legal misunderstandings, common in sovereign citizen rhetoric. At one point, he even denies his racial identity and insists he's simply a living man, which seems to be a reference to a belief system detached from legal reality. It's hard to make sense of what he's saying, and it
Go on the record in the state of Wisconsin versus Anthony Griffin Jr., case number 25 CF 939. Could you get the appearances, please?
Assistant District Attorney Jack Schneider for the state of Wisconsin.
And you're Mr. Griffin, is that correct?
No, all statements for the record comes now the living man, Anthony of the Griffin family.
All right, so Mr. Griffin,
appearing expressly.
wait, you need to stop talking. Is
I'm
Mr. Griffin
appearing expressly.
hearing today? Are you Mr. Griffin or not?
I am Anthony of the Griffin family.
Are you the Anthony Griffin
executor of the
that is
estate
charged?
of
Stop a
Anthony.
second here.
You asked me a question, I'm answering it.
Okay, I don't want you to answer it anymore. I want a yes or no answer to a question, okay? And the question is, and I have to get the case back in front of me, I'm sorry, but bear with me. Lost my calendar. I have a simple question for you.
25 CF 939.
Are you Anthony Griffin with a date of birth of August 20th, 1985?
I am not the dead entity Anthony Griffin. I am the executor of the estate. I do not agree to be.
All right, well, we'll have to set this over and hold you in custody then until we can have a later
I will
hearing.
check, as I've been held for 72 hours without seeing a judge. That is unlawful.
But you're not Anthony
So
Griffin.
you are agreeing to violate my common law rights, is that what you're saying?
I'm asking you to, let's do this, okay. I'm gonna find probable cause that this is Mr. Griffin, that is acting in an obstructing way, but,
I object.
we'll go ahead with it. Do you have a
justice.
copy of the complaint there in front of
I
you?
object that you're obstructing my justice.
Your
And I
objection is
object
noted.
that I'm a more, you haven't
If
listened
you
to
keep
the
talking over me, we're gonna cancel
You've been
this.
talking over me. I just want to state the facts. Do you not want the facts to be stated on the case? Am I not allowed?
I need you, you're not allowed, no, you're not allowed to talk right now.
Of attorney. I am not.
Okay, let's hold him in custody, or canceling this hearing, you're gonna have to be
That's
held.
okay.
You're not willing to cooperate. Make a
Let the
record
record show that they're violating my rights.
Cooperate.
Let the record show that, please. Thank you.
Record with a note that he refused to cooperate so that an initial hearing could.
leaves many people wondering, do these individuals actually believe these ideas, or are they intentionally trying to disrupt the court system? Feel free to share your thoughts in the comments after you watch this incredible exchange between a calm but firm judge and a very uncooperative defendant. This was his first court appearance after spending 72 hours in jail. From what we can gather, he likely refused to sign the required paperwork, something that simply confirms the person will appear in court when scheduled. When someone refuses to sign, they remain in custody until the court sees them. It's a pretty straightforward process, but when someone refuses to participate, they just end up waiting in a cell unnecessarily. Now, credit where it's due.
We'll go on the record in the state of Wisconsin versus Anthony Griffin Jr. That's 25 CF 939 appearances.
So we mark up for the state.
Understand order the public defender's office defers to Mr. Griffin, who's indicated that he wants to take care of his own case.
Right, is that right, Mr. Griffin?
I'm not Mr. Griffin, I'm Anthony of the Griffin. I am the power of attorney for him. I do have a question, but the court will I be allowed to speak freely, or will my civil rights be again granted on?
Oh, you get to make a statement on bail, but we're going to do this in an orderly fashion. But you're indicating that you're not Mr. Griffin, or that's just not how you identify yourself.
It's not about me identifying myself and the Griffin carries my all caps entity with the dead entity. I actually have an EIN for this, what they created entity. This is not me. I also do not live this address. I'm also not a black man. I am a Lord. So a lot of things on here are totally wrong, which cannot be at all. My weight is not 240 pounds. All this information is false. But as for the record, all statements for the record comes now the living man and the other different families. Sure, yours or your son status appearing expressly to continue the rigorous supporting. I'm not to be mistaken with the all caps state as I am the occupant of the executive office and also the sole beneficiary of the state. I filed my power of attorney with the court and I'm ready to proceed. Let the record show that I do not agree to be a surety for the debt entity as it was created from the state and was given to me and is not a representation of me. I am not going to owe debt to the United States or to the state of Wisconsin. Further, I'm not a flight risk. The only reason I missed support was due to the failure of the court to notify me of said date. Furthermore, on being detained, I made it very clear to Officer Gilson that I wanted my rights read to me. Officer Gilson first refused after we asked him twice to know if they read me my rights. After Officer Gilson read me my rights, I made it very clear to him that I wanted my attorney present with the sheriff. Officer Gilson then replied, "They won't come." I made it very clear to him that if he continued to talk to me without my attorney present and the sheriff present, it would be a violation of my civil rights and my constitutional rights. He ignored these facts and continued to be arrested in violation of my law and the rights and the protocol that he agreed to follow as an officer. I was pulled over while I was traveling in a private automobile. The plates read, DOT exempt, do not detain private travel. I made it very clear to him that he does not have jurisdiction, but yet he forced it. I was never properly identified as a suspect. My fingerprints were taken under direct arrest of origin after I told them I did not want my fingerprints or people taken until I have a court order from the judge. I do not argue with any of the facts in this charge against me. This is not me taking at a plea. This is accepted for value and returned for value. All the charges continues in this case and use my exemption for discharge and set off and release the order to me immediately.
Okay. Well, I think there's at least a reasonable inference on the record that the person known as Anthony Griffin is the same individual in front of me. When they called Anthony Griffin's case, he came out of the holding cell. I don't know why he would do that if he's not. I gave you an opportunity to speak. I'm speaking now, sir.
The judge handled the situation with efficiency and composure. While many judges might have allowed the defendant to speak endlessly, hoping he'd tire out, this one set clear boundaries. He kept the court moving forward and didn't allow the hearing to spiral into nonsense. It was a textbook example of maintaining order while still respecting legal procedures. Let's take a look at his second appearance, where things somehow become even more unruly. This hearing serves as a perfect example of why many legal professionals dread encounters with sovereign citizens. These individuals tend to argue simply for the sake of arguing. Even when addressed respectfully, they often object to any response or correction, refusing to accept anything that doesn't fit their personal view of the law.
You can object. There's no basis for it. I'm looking at the court records. Please don't interrupt. I'm looking at the jail records.
The Trust Act of 1666 says that when somebody claims their estate, you are to relinquish all of the things to them.
I don't know what you're talking about.
That's okay. That also means that this
You
is not
can file your written motions, Mr. Griffin.
court with jurisdiction, and I challenge jurisdiction under Federal Rule of Procedure 5.1.
It's denied. The booking photo and the Spillman records match this particular individual. I'll find probable cause.
Man can be lowered over his own case.
And where would you like us to send mail, sir?
You already have mail.
Okay,
53532.
thank you.
And I have a right to be
What's the state's position on bail?
Thank you, Your Honor. In this case, the state is asking the court to impose $1,000 kind of bail with the condition that the defendant be prohibited from possessing any dangerous weapons as defined by the respective statutes. It's my understanding that the defendant posted $5,000 cash on his current pending felony case and then failed to appear in court. He is alleged to have refused to identify himself and has committed additional crimes while out on cash bail, which is, as we know, a general violation of our conditions.
I object.
It's our position that
Let her finish. We can't have this hearing. We are talking over people. We're trying to record it. What's the basis for the
The
objection?
basis for the objection is the fact that she has no basis of knowing who I am. I don't know who she is.
All right.
She's not even.
The objection's overruled.
Overruled
I
objection.
ruled it, Mr. Griffin. let her finish.
As far as that failure to appear, Your Honor, it looks like a bench warrant for a body only hold was issued on January 27th of this year in pending case 24 CF 907. That warrant was not served until almost 3 months later on the 17th of April this year.
So Your Honor, they're sure not that when somebody has a court date that they have to be served a court date so they know that it's there? Or is it okay to actually set a court date without notifying the defendant or the accused and then locking them up for warrant?
All right, and I gather you're alleging that Judge Highland did not send notice to you?
No, there's no certified anything there. There's no document or proof of service of anything of that date. I went to every previous court date and I don't skip court date. He didn't show up for the last 3 court dates prior to that, and I actually put in a motion for failure to prosecute, yet they still moved forward as if nothing was placed in and no one came to court except for me and the prosecutor, and the judge was hiding in the back or whatever the case may be. I filed an abatement, just to let them know I'm not the person who they're looking for, but yet I keep getting trampled over in court. My rights keep trampled over in court. You have this person standing to the left of me who knows me not at all, and yet I would like her to take the stand and talk about how she knows me personally, because you cannot be a beneficiary.
Well, we're not going to be
She's
doing any of that,
as the
Mr.
state,
Griffin.
and she is not the state. I know her not. So I don't understand what's going on.
In this case, the defendant starts making incoherent statements about fingerprints and again insists he is not a black man, something clearly intended to confuse or challenge the court's jurisdiction. It reaches a point where you begin to question whether he actually believes what he's saying or if he's just trying to frustrate the process. Regardless, it's difficult for anyone to respond rationally when logic is taken off the table. By the time we get to the arraignment, the tone hasn't changed. The defendant is combative and disorganized, launching into more claims based on completely inaccurate legal concepts. He behaves as if he's in a competition, determined to dominate the hearing rather than participate in it properly. You can't.
All right, well, it looks like they mailed notice to the address that you had on file at the time.
So
But you're going to have to take that up with Judge Highland. That case is not before me. Looks like he's issued a body-only warrant. You can't get released on that until you have a hearing with Judge Highland in that case. I think given the history, $1,000 cash bail is necessary. I will set that.
I object. It's clear that
And that's
procedures
fine.
have been violated and you're still moving forward. This is called an
I
obstruction of justice.
don't
Let
think
the
that
record
your
show
rights have
that.
been
Know
violated.
everything that I've said.
It's all being recorded, Mr.
I'm
Griffin.
glad.
You would have the right to a preliminary hearing in 10 days. Do you want that scheduled?
Well, I don't want to sit in jail any longer.
Okay, well, You're gonna have to get a hearing in front of Judge Highland on the other case. Right now, you're not allowed to post any cash bail to get released in that particular case. I don't have any authority to do anything with that.
So if you don't have authority, that means
You're
you don't
gonna
have
have
authority over
you're gonna
me.
have to address
I object.
that
If you don't
case
have
with him.
authority to actually set me a bail, you do not have authority over me. Matter of fact, Your Honor, are you responsible for me if something happens to me?
All right, and I'll also order that you not use or possess dangerous weapons as it's defined by the state
You're
statute.
responsible for that.
And because I haven't heard a response, I don't believe we have a waiver of time limits to set a time for
Are you
preliminary
responsible
hearing.
for me if something happens?
And we are adjourned.
Okay,
Mr.
since
Griffin.
you're not responsible for me if something happens to me, let the record show that you are not. You are crazy. Bad.
Help but feel for the prosecutor in this situation. She's trying to do her job, but instead of presenting a case, she's forced to navigate a maze of nonsensical arguments. You get the sense that simply being in the same courtroom is mentally exhausting. On the bright side, standing next to someone spouting such confusion might actually make everyone else feel more competent by comparison. Still, anyone who manages to stay composed through this deserves recognition. Eventually, the hearing concludes, and the defendant is taken back to his cell. This wasn't someone who casually picked up some odd ideas from a fellow inmate. No, this individual appears to be fully immersed in the sovereign citizen ideology. He had all the usual signs: counterfeit license plates, false identification, and unwavering belief in legal myths. Despite all the disruption, the judge handled it exceptionally well. He remained professional, gave the defendant the chance to speak, as required by law, and then firmly brought the hearing to a close when it was clear there was no productive path forward. That's exactly how situations like this should be addressed. Give the person room to speak within reason, but don't allow the court's time to be wasted.